LB 463. Senator Chambers.
Thank you, Mr. President. I'd like to ask Senator Johnson a question.
Senator Johnson, would you yield for a question?
Sir.
Senator Johnson, you mentioned that a great amount of work had been done on this bill, and you mentioned that there are 1,000, how many pages did you say?
1,053, I believe, Senator.
And there are over 1,300 sections.
It's an amazing number. We tried compiling that on the handout to show how extensive it is.
And Senator Shimmick said nobody is probably going to read it all, I think. And we'll trust you, right?
And I have not read it all, sir. But I think in defense of that, Jeff Santema, believe it or not, has read it all. And so I rely on him, as do most people.
Senator Johnson, who was elected, you or Mr. Santema?
I was.
And who has the responsibility to discharge the duties of the position which you hold?
I do.
Would one of those duties be to read the bill that you report out and recommend that we accept on your say-so?
I wouldn't say that exactly. I'd say that it was my duty to find extremely competent people to go through that and rather than reading all the bill itself.
So it's like a joke that said there was a story going around and one of the gossips told the sexton and the sexton told the bell. When the sexton was told, it was T-O-L-D. When he told the bell, it was T-O-L-L-E-D. I like plays on words. So what we're doing is having information that was given to you by another person, then in turn given by you to us, and we're to accept what you represent to us that this bill says. Is that an accurate reflection of what we're doing this morning?
Senator, I don't think it would be quite accurate, because one of the things that we've had is that all of these various entities
That's not what I'm asking
are licensed.
You're going by what you were told by your competent staff members. Is that correct?
Not only my competent staff members, but by all of these groups that have been meeting over the years.
So that we have double or triple or quadruple hearsay, but in effect, you are telling us what others told you is in the bill. Is that accurate?
I think you could state it that way if you chose.
And you say this is an important bill.
Yes, sir.
Do we have an obligation, do you think, to read it or just to trust you?
I don't think that you need to trust me. I think we need to trust all of the people in these various professions working with various staffs to come to the common agreement. And
but we don't know what they said, do we?
Well,
that's all I'll ask you.
Sure, certainly.
Mr. President, pursuant to Rule 6, Section 3A, this is what you find. The clerk of the legislature shall read the number and the title of the bill and the name of the principal introducer as it comes up for consideration on general file. A bill will not be read section by section unless requested by a member of the legislature. Sub B, each section shall be open to amendment. I'm invoking this rule and requesting that the clerk begin to read this bill section by section, with each one being open to amendment. And I'd like a ruling from the chair as to whether that is in order.
The request is in order. Shall be allowed.
Mr. President.
Mr. Clerk, would you prepare to begin reading Legislative Bill 463, beginning with the first section?
Mr. President, Section 1, Section 71-101, a revised statute cumulative supplement 2006.
That is the conclusion of the first section of the Act. Any discussion?
Mr. President, members of the legislature, I'm going to ask Senator Johnson a softball question first. Senator Johnson, would you turn to page 13 of the bill?
Senator Johnson, would you yield for a question?
Yes, sir. Hang on for 1 second, Senator, and I'll see what I can do.
Oh, you can do it if you try.
Oh, I'm sure I can too. 13?
Yes.
Yes, sir.
Beginning in line 21, it tells where the reviser of statutes is going to place these various provisions, and they'll be in Chapter 38 in the order listed in this bill. Is that correct?
That's what it says, sir.
Okay. And there must be someplace else, because it's a different subject, where the Water Well Standards and Contractors Practice Act would be placed, correct?
Yes, I would. And what I understand is that this is a reordering. I'm sorry, I can't quite see you, Senator, but that these are now scattered about might be the best term, and then to try and get these in logical order is my understanding.
Okay, so this is done now to create a grouping of these provisions which currently does not exist in statute, more or less?
It's my understanding that over the years, and I think this actually started in 1927, and with all the different laws and so on that have been passed, that they're here, there, and everywhere, I guess might be the best way of putting it.
Okay, thank you. That's all I would have on that. Thank you, Mr. President.
Thank you, Senator Chambers. Further questions, discussion on Section 1? Seeing none, Mr. Clerk, we're ready to proceed with Section 2.
Section 2, the legislature recognizes the regulation person and business providing health and health-related services, environmental services, as the intent of the legislature provides such regulations of the Uniform Credentialing Act. It's the intent of the legislature not to impose any requirements beyond those in effect immediately prior to the operative date of this section on school districts, educational service units, other public or private educational institutions or entities serving pre-kindergarten through 12th grade students.
Thank you, Mr. Clerk. Questions on Section 2? Senator Chambers.
Senator Johnson, on page 15, starting in line 23, it is the intent of the legislature to not impose any requirement beyond those in effect immediately prior to the operative date of this section on school districts, educational service units, and so forth. Does that mean that a different rule is in place with reference to every other entity that is affected by this bill, so that things can be added after the effective date of this act, which are not mentioned in this act?
Senator Johnson, would you yield to a question?
Yes. Senator Chambers, one of the groups that in talking about whether I'd actually read this bill or not, we certainly did have different groups that came around to my office to discuss various parts of this. One of them was a school district that was concerned about how this might affect nurses in their schools and how they might be changed by this. What I asked them to do is to allow this bill to be enacted, because as we talked earlier, we will have more than a year, in fact almost a year and a half, for various studies and bills to correct the concerns about this school district regarding their nurses. So that's the best I can answer it, I think. But
okay, between the time that this bill before us would be enacted and the time that it would take effect, additional laws could be put in place that would affect these nurses located in these facilities. Is that correct?
yes, sir.
And whatever is done in those laws would apply.
This, as I think the best way of looking at it is, this is our starting point, and then so that we reorganize where we're at, and then it is the starting point of where we might go from here. And, you know, there will always be need or desire for change of the law.
Here's what doesn't make sense. and maybe I misunderstood you. What is the earliest date that anything in this bill will take effect?
This bill goes into effect on December 1st, 2008.
Which is next year.
Yes, sir.
So why do we need this language that is put here? This language cannot stop the legislature from enacting different legislation or even repealing this bill next session. Is that true?
That would be true, and we could have another bill next week that would have an effect on this, I would think.
So
sir.
what sense does this make? Why is this language necessary? I'm going to read it again. It is the intent of the legislature to not impose any requirements beyond those in effect immediately prior to the operative date of this section on school districts and so forth. Well, nothing in this bill has effect on any entity prior to the effective date of the bill. Isn't that true?
That would be correct.
So what are these people worried about, and why is this language here?
Sir, I cannot give you
1 minute.
any other answer than what we've talked about.
If I would strike it, it wouldn't hurt the bill or anything else, would it?
At first glance, no.
Okay, and I'm not going to do it right now, but these are some of the things that I'm being made aware of as we proceed in this fashion.
Certainly.
And that is all the questioning I would have on this provision, this section, although at a later time I may come back to deal with this. Thank you, Mr. President.
Thank you, Senator Chambers. Senator Chambers, that was your third time.
On the bill, right?
Oh, correct. Under the time we're on discussion of advancing LB 463, each member is allowed up to 3 times. Each section is not a separate question.
Gotcha. Thank you.
Thank you, Senator Chambers. Senator Rogert.
Thank you, Mr. President. I yield my time to Senator Chambers.
Senator Chambers.
Thank you, Senator Rogert. This is done partly to give everybody a chance to look at the bill, come to an understanding of what it is we're dealing with. And I ask questions when I don't know the answer to what I read. And when I see unnecessary language, I think it should be removed. So in the time that Senator Rogert has given me, Mr. President, even though I'm not speaking, I want the time to run, and I'm going to take this opportunity to draft an amendment because we will be off this section before I would have a chance to do so. I will continue, Mr. President. Members of the legislature, I'm going to go ahead and have the amendment drafted, and I'm going to explain why again. If you start in line 19 of page 15, it says, the legislature recognizes the need for regulation of persons and businesses providing health and health-related services and environmental services. It is the intent of the legislature to provide for such regulation through the Uniform Credentialing Act. That's enough. Then here comes the superfluous language that really has no meaning. And this is what I'm having stricken. It is the intent of the legislature to not impose any requirements beyond those in effect immediately prior to the operative date of this section on school districts, educational service units, and so forth. First of all, We cannot bind the legislature next year not to enact new regulations if that's what if that's the purpose of this language. We cannot bind the legislature and prevent ourselves from imposing new regulations. If that is not the intent, then all it's saying is that this bill will take effect on the effective date of the bill. Anything in this bill that has a bearing on the individuals affected under this language that I want to strike, those regulations will take effect on the effective date of the bill. And if they're not in the bill, they're not going to take effect. But if they are in the bill, they are going to take effect. So why are you going to say, nothing in this bill shall take effect on this category of persons before the effective date of the bill, when you don't say that about every other entity that is affected? Senator Johnson, do you see what I'm saying, whether you agree with it or not? If Senator Johnson would yield to a question.
Senator Johnson, would you yield?
Certainly.
Senator Johnson.
1 minute.
Have you been able to follow what I have been saying about this language?
I've been trying diligently.
Okay, but it's not clear to you? If it's not clear, then when my amendment comes up, I'll be able to discuss it in more detail, because I'm offering a motion to strike it. It serves no purpose whatsoever. And when the amendment is prepared and is offered, you and others who may agree with this language because your committee agreed to put it in here or leave it here can explain to me how the language means something other than what I take it to mean. And I'm basing my understanding on what it means from the plain, ordinary usage of these words. So is my time up on this, Mr. President?
Time, Senator.
Thank you.
Amendment filed at your desk.
Senator Chambers would move to amend this section, Mr. President.
Senator Chambers, you're recognized to open on Floor Amendment 69.
Thank you. Mr. President, I have to do everything. See, since I have the clerk doing this extra work, I think I should do my part as we go through these sections. But I may not have the time on each one to proffer, as they would say under the law, an amendment. But I'm going to try to stay caught up if I can. This is the language that is being stricken. You will find it beginning in line 23 on page 15, and it will continue through lines 1 through 3 on page 16. And for the sake of the record, I'm going to read the language that I'm striking, and I'm not replacing it with anything. It is the intent of the legislature to not impose any requirements beyond those in effect immediately prior to the operative date of this section on school districts, educational service units, or other public or private educational institutions or entities serving pre-kindergarten through 12th grade students. I would like to ask Senator Johnson a question or two if he will yield, Mr. President.
Senator Johnson, would you yield to questions?
Certainly.
Senator Johnson, who came to you with this language because you said some groups were concerned and they wanted this language in the bill?
I think that might be an oversimplification, Senator. And by the way, I've turned on my lights so that you can have my time, too, if necessary. But at any rate, no. I think what we have here is the cumulative opinions of all of these 39 different groups working over the years to come to this. And then,
but what I'm speaking of is with specific reference to the language that I want to strike. These different educational entities, did they have a delegation come to you, or did they designate somebody?
No, I'm sure that the language itself was worked out in each of these instances with the staff of HHS and so on, being the staff for these different entities would be the way I would think of it.
Now, going to the language that I'm looking at.
Okay. And you're going back to page 15, sir?
Yes, under this bill, the only thing that will take effect when this bill reaches its effective date of December of next year or 2008 will be what is in this bill. Is that correct?
That would be what was in this bill would go into effect December 1st of 2008. And of course, as we've talked, why there would be the ability of any of the senators to bring forth legislation in the interim that then would be effective.
And you would agree, I believe, that one legislature cannot bind a future legislature. Do you agree?
That's always been my understanding.
So it being acknowledged that we can impose additional requirements that go beyond what's contained in this bill, we can do that. What is the significance of this language? Because it can't stop us from doing that, and nothing other than what's in this bill is going to have an impact on those people. Or is there something in this bill that says certain things with reference to this category of persons will take effect after December, whatever it is? And even if that's the case, the effective date of that section will determine what in this bill will affect them. In other words, this language makes no sense to me. I understand what it's saying, but it's unnecessary and serves no purpose. So if it's stricken, let me ask the question this way. If this language is stricken, how will it hurt the bill?
Senator Chambers, as I mentioned when we first began this conversation, my first impression is that I can't see where it will, and after thinking about this, I can't think of any reason to this point to think differently than that.
Okay, thank you, Senator Johnson. Mr. President, what I'm going to do then, if there are no lights on and people are not going to ask questions, is just wrap this up. Are there any lights on?
Yes, we have 5.
Okay, then they may want to ask me questions, so I will listen to those questions and answer them. Thank you, Mr. President.
Thank you, Senator Chambers.
Chambers, may I ask you a question?
Senator Chambers, would you yield to a question?
Yes, I will.
You're not a mind reader, are you, Senator Chambers?
Well, I don't want to tell everything, but occasionally I can pick up vibrations.
To which senator were you referring when you said somebody was going to give you time?
Whoever the hat fits is the one to whom I was referring.
I'd like to give my time to Senator Chambers.
Thank you. 4:30.
Thank you, Mr. President. Thank you, Senator Shimmick. Members of the legislature, let me try to give an analogy since I have a little more time so that what I'm saying is clear. Let's say that a rule or regulation that is currently on file with the Secretary of State is valid, and it has 10 provisions. When this Credentialing Act takes effect, the last 4 of those provisions are in conflict, so they no longer remain in effect. But if you, as a member of the public, would ask the Secretary of State for a copy of rule or regulation, whatever it is that we're talking with, you will see all 10 of those points. And you'd be entitled, as a member of the public, to rely on this copy that you get as being an accurate reflection of a rule or regulation that is in effect. So what I think should be done, and language should be crafted to do that, is to say that a determination must be made by somebody as to which portions of rules and regulations may be in conflict with this statute and therefore no longer in effect. Then require that an amendment be filed in the Secretary of State's office that will accompany that existing rule or regulation, which will say that parts 7, 8, 9, 10 are no longer in effect. or simply have the agency repromulgate, adopt, and file its rules and regulations as they would do. It makes no sense to me to have this kind of language when it can mislead the public. Who is going to determine? Is Senator Johnson here? I don't see it. Oh, okay. We can't see each other because sometimes a person intervenes. Senator Johnson, I'd like to ask you a question.
Senator Johnson, would you yield to a question?
Yes, sir.
Senator Johnson, who is the one responsible for determining which parts of rules and regulations that currently exist are in conflict with this law when it takes effect? On whom is that responsibility placed? Under the law, nobody is it.
I was going to say, if there is a person, I don't know who it is.
And the law does not specify who will make a determination of which existing rules and regulations conflict with this law. Would you agree?
That would seem reasonable.
Would it make sense, since the public is entitled to rely on what is filed with the Secretary of State, they're entitled to rely on the accuracy of those documents. If nobody is assigned the duty of finding where a conflict exists, then the public is entitled to believe that that entire rule or regulation is valid, even if half of it conflicts with the law. Wouldn't you have to agree with that?
Well, yes and no. I think, Senator, one of the things, of course, is, and as you've mentioned in here on several occasions, is that the 49 of us here are the ones that determine what are the laws in the state of Nebraska. Now, whether it's here or on the federal level, certainly the rules and regulations that then come about are in effect. So,
Mr. Clerk, do you have a motion?
Mr. President, Senator Chambers would move to amend this Section 4 of Legislative Bill 463.
Senator Chambers, you are recognized to open on your motion.
Thank you. Mr. President and members of the legislature, Section 4 contains 3 subsections. My motion is to strike all of Section 4. To strike all of Section 4. Since my amendment is an amendment to the bill itself, my amendment can itself be amended. So if there's a portion of Section 4 which somebody thinks should be spared, a person could amend my amendment, and I might wind up having to do it. But I want to continue this discussion, and I'm not going to do it by way of question and answer with Senator Johnson, because being practical and fair, I doubt that anybody would read and analyze all of these sections. I didn't get the agenda until this morning. I take seriously what it is that I do. When people talk about how hard I work, I tell them, but I'm paid to do what I do. I'm not paid well, but I'm paid to do what I do. And when I enter an agreement and I promise to provide a service in exchange for money or compensation, then I'm going to perform that service the best that I can. When I was a barber, I was very good at what I did. There were 3 barber shops in the same block. One guy on the far end of the block said his barbers cut hair better than anybody in the world. The guy next to him said his barbers cut hair better than anybody in the universe. The shop where I worked said we cut hair better than anybody on this block. So this work is painstaking, it's meticulous, but it's necessary to be done. Language may, at first blush, seem to be suitable and acceptable. I understand the principle that is being sought here, but I don't think that the language is acceptable. And you all may disagree with me, but I'm going to look at subsection 1, which is what I was discussing. Any rule, and I'm paraphrasing, any rule that was properly adopted prior to the enactment of this law will remain in effect after this law takes effect, except any portions of that rule which conflict with this law. There is nothing in this bill, there is nothing when it becomes law which says who is to make a determination that there's a conflict between the regulation or any part of it and this law. So if the responsibility is placed on nobody by law, there is nobody who can be responsible for doing this. So it becomes a portion of law that is unenforceable and therefore of no value. They either ought to say any rule or regulation properly adopted before the enactment of this law remains in effect, period. But if they are aware that some existing rules and regulations may conflict with the law, they should either place a requirement on the Attorney General's office, on whoever the director of the agency affected is, to study the law as it impacts on their rules and regulations, determine any conflicts that exist, and if they're unsure, get an Attorney General's opinion. And once it is established by whatever means that a conflict exists, either require the scrapping of that rule and regulation and adopt one which conforms to the law, or require that an amendment to that rule or regulation be formulated and attached to every copy of that rule or regulation which exists in the hands of the state. And if any member of the public or anybody else requests a copy of that rule or regulation, it should be accompanied by that amendment. But since that could be cumbersome, why not require a reevaluation of rules and regulations that were adopted prior to the enactment of this bill? Any rules and regulations found to be in compliance will stand unless the agency amends them in the way that the law says. But forget about amending them. They stand. Any rule or regulation which is in conflict is nullified by the law, and a rule or regulation to replace it would have to be promulgated, adopted, and filed by that agency in accordance with the law. And they'd find those requirements in the Administrative Procedure Act. But they know how to do that. If you agree with what I'm saying, then you will adopt my amendment. But there are other parts of Section 4 that are implicated. I didn't have the time to go through each one of these subdivisions and see which might be all right. But if you go to subsection 2, it says, all licenses, certificates, registrations, permits, and so forth, or other forms of approval issued prior to the operative date of this section, in accordance with the Uniform Licensing Law or other statutes amended or repealed by this legislative bill. In other words, any of these items which were legally adopted at the time they were adopted will remain valid unless revoked or their effectiveness is otherwise terminated pursuant to law. What law? They mean that an additional law has to be enacted to invalidate something that has been made invalid by this law. Here's what they're saying. This law, by its terms, may make something that exists invalid. But that's not going to be done by this law. The legislature must pass another law to do that. Or, if they mean pursuant to law, is there some other law existing right now which would make it invalid? Why cannot this be simplified and simply say what is meant to be said? But I'll tell you what, you all don't have to adopt my amendment, but I'm making a record to show that there are problems with this bill. And when these chickens come home to roost, don't shake your head and cluck, cluck like chickens and say, oh, what a terrible thing. Senator Johnson pointed out that we're the legislators. We're the ones who enact the laws. We should take care in how we enact these laws. And even though this is a thick bill, and there are other things people want to get to, I've got a bill farther down dealing with mixed martial arts regulation. That has nothing to do with this bill. We should deal with this bill and get it right. I don't know if Senator Johnson is sitting over there now or not because, oh, I'd like to ask Senator Johnson a question or two. And how much time do I have, Mr. President?
1 minute. Senator Johnson, would you yield to a question?
Yes, sir.
Senator Johnson, I know you've been busy probably explaining the bill and talking it to others. Have you been able to follow any of what I've been saying with reference to this issue?
Well, I've tried to, sir, but not on this most recent part.
Okay, but you know that under this term, the terms of this law, there is nobody assigned the duty of determining if a conflict exists, is there?
I think that'd be true of all laws, would it not?
We're talking about this law because I haven't seen any law written like this one before where you say something that was done before the law remains legal except where it conflicts with this law. When we're going to change something in an existing law, we strike that language when we enact a new law. We're not striking any rule or regulation here. We're saying let them all stand unless they conflict. But there's nobody who makes that determination. Are you aware that rules and regulations have to be filed with the Secretary of State? Oh, you said time? Thank you, Mr. President.
Thank you.
And those of you who grow impatient, I can only ask questions of the introducer of the bill. And if the introducer doesn't have answers, somebody else raise their hand if they can answer, and I'll call on that person. Senator Johnson, these are not designed to be trick or embarrassing questions. Will you accept what I say as being valid, that these rules and regulations are filed, must be filed with some agency of government, and that the public can have access to those rules or regulations?
Senator Johnson, would you yield to the question?
Yes. I would think that that would be the case, and our counsel here said that by and large that these rules and regulations do go by the Attorney General's office.
Right. In order to be adopted in the first instance, right, they must go through the Attorney General's office and the Governor's office. So I'm getting past that point to where we are with a rule or regulation that was properly adopted, and it's in place right now. So that rule or regulation is adopted now. Did your counsel point out to you that these rules must be filed with the Secretary of State's office?
Well, you did earlier.
Okay,
sir.
well, do you accept that, in other words? Okay, and they're also to be made available to the public upon request. And I don't know if you have to pay a fee or something, but the point is they have to be available to the public.
That would seem very reasonable.
Now, what this law is saying, that any of those rules and regulations which do not conflict with this law, even though they were enacted before this law takes effect, will remain legal. Do you agree with that?
Well, the intent is, as we talked earlier, Senator, is that there is no change of scope of practice and this type of procedure, so that that would seem to be the case, that you wouldn't, since those are meant to remain intact, and that this is just, reorganization might not be quite the right word,
but I follow
but that's
you.
the intent.
Okay. However, there's another proviso in this language I'm discussing. Those parts will remain in effect that do not conflict with this law. Isn't that what this language says in subsection 1 of section 4 on page 16? If you go to line 16, to the extent not in conflict with the act.
Senator, what page and what line again?
Okay, page 16.
Yes.
Section 4 and subsection 1 begins in line 12.
Yes, sir.
Any of those rules and regulations will remain effective to the extent not in conflict with the act until revised, amended, repealed, or nullified pursuant to law. Now, if they are in conflict, but they're not revised, then they remain effective even if in conflict with the law. Is that correct based on the language we have here?
1 minute.
I'm just not sure that I can answer that, Senator.
Okay. Members of the legislature, I have 1 minute left, but I've got to keep going over this. I want the record clear. Apparently, my explanation or my questions are not clear. I didn't put any language in this bill. I want to understand it. Obviously, a rule or regulation that conflicts with a law cannot trump the law. Otherwise, you're allowing some other entity to have more power than the legislature, but we're the only ones under the Constitution who can legislate. If we want a rule or regulation to overcome what we enact into law, we have to enact that rule or regulation into law and within its body.
Time.
Thank you, Mr. President. Legislature, this is some of the most confusing language that I have come across in a long time. And that's not to say people were not putting this together in good faith. But you cannot just go by the sound of the words when you read them. You have to look at the legal effect of these words. And I'm going to keep repeating what I'm talking about because there's nobody I can question as to what was meant by this language because the chairman is unsure. So since there's nobody I can question, I've got to make as clear a record as I can. And by the way, do you notice how many people are gone from the chamber? If they have a bill, then they're up here and they want everybody to be here. This is not my bill. I might have fewer bills than most of the senators. Did you say time, Mr. President?
1 minute.
Oh, thank you. We all have a responsibility, and I'm going to assume mine. And I know you all will probably automatically vote against what I offer here because you don't understand it, but you're taking it all on faith. But I don't want to look like a jackass. So I'm going to make the record. And if what I'm saying is not correct, correct me. If you have a different understanding, tell me what it is and improve my education. What they ought to do really with this is require the agency to review its rules and regulations. Here's where I'm frustrated. This bill is not going to take effect until December of 2008. Every agency can look at what's in this bill relative to their agency and get their rules and regulations into conformance with thank you, Mr. President.
Thank you.
Hirsch, members of the legislature, it's good that Senator Shimmick narrowed the amendment to deal with subsection 1 of section 4. I'm going to read this language. All rules and regulations adopted prior to the operative date of this section, which that date would be December of next year, December of 2008, under the Uniform Licensing Law or other statutes amended or repealed by this legislative bill. That means that even though this section, that this bill itself, meaning this huge monstrosity, may repeal or modify other sections of law under which those rules or regulations were adopted. Even if that happens, those rules and regulations will remain in effect under the Uniform Credentialing Act to the extent not in conflict with the Act. To the extent not in conflict. Let me pause there. Senator Johnson admits that nobody determines that a conflict exists. So the rules on file now in the Secretary of State's office may not be completely in harmony with this act. So let me make it simple. Let me say that the entire rule is in conflict with this law. That means the whole rule has no effect whatsoever. But if you go to the Secretary of State's office after the effective date of this act and ask for the rules related to this particular entity, you get that rule. But the rule is not in effect because this law says it's in effect only if it doesn't conflict with this act. Who knows whether it conflicts or not? That's not the Secretary of State's job. It's not the job of the Attorney General. It's not the job of anybody. You all talk about children in school not paying attention. You all are grown. You may not have been an adult as long as I have been, but you are as grown as I am. You have as much responsibility as I have to legislate, probably more. Because this is not my system. This is a system of, by, and for white people. And people don't like to hear me say that. But who are all the directors? Who are all the mid-level people with the authority? We all know the answer to those questions. But you all don't care. You know why? Because the law doesn't apply when you all are involved. All you have to do is say, I want to do this. And it's done. You said time? 1 minute? All right.
1 minute, Senator.
I've said over and over and over, if there's a problem with legislation which is before us, why do we sit like knots on logs instead of dealing with it to correct it? Now, if somebody on this floor can show me where in this law there's an identification of who is to determine if there's a conflict between an existing rule and regulation and this act, let that person stand up and show me. I didn't draft this language. You all did, whoever you are. And it doesn't make sense. It's impractical. It doesn't alert the public as to what the status of rules and regulations are. But you don't care. So why should I?
Time,
because
Senator.
I'm naive. Thank you, Mr. President. I'm going to have to talk to those people so they can explain it to me. Not that you were not clear, but even if they said what you said, there's a different and better way to say it. Just because it's been said this way in the past doesn't mean it's the best and clearest and most effective way to say it. If I understood what you said they told you, is that they're looking at a period of time between when this bill takes effect, which would be 90 days after the session.
No, in this case, it's the end of 2008.
No, but here's what I mean. This bill, okay, so then it doesn't take, no part of it takes effect until 2008.
Yeah, it's either the last day of December of 2008 or the first day. It becomes effective January 1, 2009.
But this bill still becomes law 90 days after we're out of session. And
Well,
its
that's true.
terms will say when the effective date is.
That's true, yes.
Okay, so they're looking at a period between 90 days after we're out of session and December of 2008. And they told you, if I understood correctly, that they have rules in place, and during that period, they're going to change those rules to comply with what will be in this bill.
They're going to be
1
looking at the
minute.
changes that need to be made. And then after the law actually becomes effective, then at that point, they are empowered to do hearings and do all of that kind of thing. And it has to be run by the AG and governor, and I'm not sure at what point all of that happens. But until those rules are actually then in effect, there's a time lag. And there always is a time lag. But they'll get a head start on this time lag because they've got all this time before the end of 2008.
Did they say who assumes the responsibility for determining conflicts between rules and regulations that are going to have to be changed and the Act, the provisions of the Act?
No, they didn't, Senator, but I would presume, again, it would be the people who do the licensing and so forth that's covered by the bill, that they will be the ones that will be promulgating those rules.
We could put all that into
Time,
statute.
Senator.
Thank you, Mr. President.
Senator Chambers, followed by Senator Nelson, Senator Friend, and Senator Persh. Senator Chambers.
Thank you, Mr. President. Senator Shimmick, and I'm not making you the advocate or the spokesperson for whoever you talk to, but to try to get clear what at least was said by you.
Senator Shimmick, would you yield?
Thank you, Mr. President. Yes, Senator, and I don't have the same kind of knowledge that the people back there do about how all this process works, but I feel more comfortable with the language now and understand at least why it was put in. And I tried to explain that as much as I could to the body.
So what did they say about the language that says in line 16, to the extent not in conflict with the Act? Did they say that there are provisions of their rules and regulations, which will be their existing rules and regulations, which will be out of conformance with the Act, and those provisions will not be legal?
They did not say that explicitly, but that would be my assumption.
And that's what the language would indicate here.
Right.
Okay. Those rules and regulations, whatever they happen to be, would remain effective, the parts that are not in conflict, until revised, amended, repealed, or nullified pursuant to law. Do they mean the existing law, which would be found in the Administrative Procedure Act, or some law that by its terms would nullify whatever rules or regulations they have adopted? Senator,
I'm sorry, you lost me on that. My mind was going in a couple of different directions.
Okay, page 16.
Yes, I've got it.
In line 16.
Right.
We've agreed that the provisions of any rules or regulations that are in conflict with this Act will not be considered valid. Correct?
That is the way I read it.
Okay, me too. Then, after that, we say that these parts that are valid, I guess, will remain in effect until revised, amended, repealed, or nullified pursuant to law.
That would be my understanding.
Then it seems to me what they're saying, since we're dealing in this language with the rules that are not in conflict, that they're going to have to revise, amend, repeal, or nullify them. But if they're already in effect, why will any of these things have to be done to them if they're in compliance with the law?
Well, there probably wouldn't have to be anything done to them, but they have to look at all of the existing rules and regs to make sure that the new ones would be.
But look at this.
Yeah.
They're in effect only until, which means either they're revised, amended, repealed, or nullified. If none of those things are done, they are not in effect. They're in effect only until these things are done. But at this point, we're talking about the provisions that are not in conflict.
I think I can't dispute what you just said, Senator.
And I'm going, remember, by what I'm reading.
And yeah, I can't dispute what you just said.
Okay, that's all I will ask you, because I think I'm on my time.
About
Okay.
1 minute.
Okay, because I didn't want to steal yours, Senator Shimmick. Members of the legislature, I want to clear what we're doing.
1 minute.
Reformulate this language and say what they mean to say. They don't have to say it in a few words if by just using a few words it's not clear what they mean. This language says that the rules and regulations, and I'm paraphrasing, that are not in conflict with this law will remain in effect until they're revised, amended, repealed, or nullified. But if they're in conformance and not in conflict, you don't have to revise them, you don't have to amend them, you don't have to repeal them or nullify them. But if you nullify them, then how do they remain in effect? I didn't write the bill. Thank you, Mr. President. Members of the legislature, if the questions that I'm raising are responded to in the way that Senator Shimmick suggested to us, why don't those people craft language to say what it is that this is supposed to mean? If it means that existing rules and regulations that they have will remain in effect until December 2008, that's what's going to happen anyway. The parts, here's what throws in the confusion, or starts the confusion, where they say the rules and regulations not in conflict with this act. They cannot be in conflict with this act in a legal sense until the operative date of these provisions, which would be December 2008. So by operation of this act, no rule or regulation is going to be affected at all until December of 2008 at the earliest. If what we're being told is intended by this language is to allow rules and regulations to stay in effect until 2008, if they don't conflict with what's in this act, that doesn't make sense. There is nothing operative in this act until December 2008, so there's nothing for those rules and regulations to conflict with. If somebody said, look, in line 18 on page 16 is a conflict with your rules and regulations, then you tell them, well, that line doesn't become law until December of 2008, and since it's not December 2008 yet, it's as though that line does not exist for purposes of the law. Nothing that... Let me try from a different angle.
1 minute.
A cow metamorphoses into a horse, and the cow will become a horse December 2008. The cow is not a horse until December 2008. Until December 2008, the cow remains a cow and there is no horse. A rule or regulation is valid no matter what this law we're talking about says until December 2008 and a possible conflict occurs. And when that conflict occurs, then that rule or regulation which is in conflict automatically is of no force and effect, because a rule cannot take priority over a statute. They need to find language to say what it is they're talking about. And I don't think it's clear.
Time, Senator, but your time now may continue.
Thank you, Mr. President. With what Senator Shimmick said, listening to Senator Nelson, I think we're getting a sensing that they want to say that for the transition from what is now until 2008 December, nothing is going to change. Well, until December of 2008, nothing is going to change anyway. Even those things that this bill will change are not going to be changed until December 2008, because until that date comes, nothing in this bill takes effect. It will not nullify a rule or regulation. It will not change a name. It will not do any of those things. I don't even know whether or not the reorganization in the statute books of these various entities will be done. Namely, that they'll all be in Chapter 38 in the sequential order that they're listed in this bill. Maybe that is done as soon as we reach 90 days after the session, but not having had a chance to examine this bill, I don't even know if that is to be done prior to December 2008. I'm going to have to be told more than what I've been told before I can be convinced that this language is necessary or serves any purpose. What the language is saying, if there are rules and regulations legally adopted before December of 2008, if they were legally adopted, they remain in effect if they're not in conflict with this law. They won't come in conflict with the law until December 2008, based on what I think I understood Senator Shimmick to say. So they will not be revising and adopting any rules or regulations until after December 2008, even though they may be going through a rewriting and revising process. So when that date comes and this bill takes effect, they'll be ready to put those things on the table. But it still doesn't hang together. I think they would be able to read the provisions in this bill even before December 2008 and determine what is existing in their rules or regulations that will be out of compliance. Why don't they draft a rule or regulation that complies with what is in this bill and state that they will have an effective date of December 2008. Do something so that there's not a gap. But they're the experts. Since we're not going to finish this today, maybe somebody can write up in clear, uncomplicated English that somebody such as myself, who was educated at OPS and whose intellect has been stunted by lead, because I grew up in a community where there was lead, so that somebody in my situation can understand what it is they mean and what it is they're trying to do.
1 minute.
And if they can write language that will explain it to me and make it clear, then why don't they just put it in the statute and make it clear for everybody? This language is not just for the agencies. It has to be for the public, so that the public and even the media can help exercise some oversight and see if the agencies are complying with the law. If there are codes and secret signs and messages being given in this language, in other words, if we're dealing with runes, R-U-N-E-S, and we're not supposed to understand it, members of the legislature, the public, then let them have a key someplace so we can go get that and look at it and compare what they're doing to what this rune says they're supposed to be doing, or these runes. Other than that, I'm still kind of adrift.